And it comes to the breaking point because right now there's these two truths coming together. Engineers say input into a large language model, anything they take off the internet, a website, social media post, etc., is not copyrightable. And if you look at copyright law, which was written back for when we all bought books, right? And when I would take this book, if I took it, I had to put it in this format to be able to sell it to somebody else. That's why the protection of a copyright is an old model that really isn't going to be able to handle things. We can't sue our way out of this. We're at a point where the old rules don't apply, and we need to move from protection to participation to move beyond sue and hope. For example, it just came out recently that OpenAI won an early dismissal of a case by Ross Story and Alternet, who said that they took their information, scraped it, and that there were, in sort of metadata, there were copyright trademarks on this content. So OpenAI came in, scraped it, and of course turned it into tokens, and all that copyright information was lost because, to OpenAI's credit, they said, well, we're never putting it back together again. The whole point is we can bring it in, but if we don't output exactly the same thing, the law can't really see what the difference is and then what the damage is to the person who had it, quote unquote, stolen. So in this case, the judge said the DMCA, the Digital Millennium Copyright Act of 1998, which was used to say OpenAI violated that act because that act says you can't separate the copyright from the original work. But the judge looked at this and said, well, I can see it in the input, but there's nothing going on here because the input doesn't actually create a product. It just creates tokens that then connect in sort of a probability-based way. Essentially a word calculator to put out answers, but it's not designed to put out the same answer. So this dismissal, which was without prejudice, meaning it could come back up, is really indicative of how copyright law looks at this and says there's nothing wrong with what's going on. And this is what the large big tech companies are banking on. And honestly, after looking into this, may be true. So the new model, create and earn. Why traditional copyright fails in an AI world. Now, there was another case on back in September 5th. The judge ruled that AI artwork can't be copyrighted. Another angle that they're going at it is not using old copyright law, but Stephen Thaler has been creating an AI for many, many years, and he sued Shira Perlmutter, the Register of Copyrights, after the Copyright Office refused to register the copyright for a purely AI-generated work he had submitted. He created the intelligent engine, AI sentient being, in his words, will eventually becoming that. He's created that for many years in artificial intelligence. So it created a work. Why can't he copyright it? Why? Because copyright law is for humans who create things in physical products. There is no way that he's going to be granted this because then they would have to grant a copyright to something created not by a human being. That's probably coming, but you can see the world of AI and copyright is messed up because we're trying to run things by the old rules, the old ways. If you're looking at Stephen Thaler and Perlmutter, they're both right and they're both wrong. If you're looking at OpenAI and Ross Story and Alternet, they're both right and they're both wrong. And that's our problem. This trying to apply law and sue our way out of it and hope in 5 years will come out. There have been significant settlements people have done in major businesses to be able to go by the scraping and basically get a licensing fee. Reuters is involved in one. Adobe's been involved in a few. There's others that are sort of happening under the radar. And the stakes here, the stakes are really high. This isn't about stopping AI. It's about something way bigger. Not protection, but performance. How does that content do? Most content does not generate performance, does not generate people listening to it. How this content actually influences whole vectors, not just the token, but the vectors to create influence and how we might not only be able to reward it. This kind of performance-based enhancement is an analytics dream, but it also goes back to finding those people who are generating enough volume to be rewarded, either with grants, payments, even credits for using the tools. There's so many ways this could be turned into a positive besides paying lawyers. It's not about barriers, but creating bridges. Not about copyright, but how do we collaborate with AI And how do we respect the creators and encourage them and give them incentive to keep creating? Because the really good stuff we still create. And if we're just waiting for AI to do it, what's it freeing up our time for? So we're going to explore two scenarios that could transform how creators and AI work together, not through courts, but actually through code.